Good afternoon. Welcome to the Appellate Division First Department oral arguments for today, March 18, 2021. I will now call the calendar. People v. Rafael Bayron, submitted. Ioannis versus Stybreck. Appellant?
Appellant Adenine Medina.
8 minutes.
Thank you, Your Honor.
Respondent?
Christopher Dennis.
8 minutes. Matter of Donique. Appellant? We should have ACS, appellant, and
I'm the respondent, Your Honor, Deborah Wassell for ACS. I believe the appellant is Marcia Egger, and she is on the call.
She responded.
Yes, I'm right here. I'm right here. I'm sorry. I had trouble unmuting myself.
Not a problem. 6
you.
for each side.
Thank you.
I reserve? I'm sorry. May I reserve one for rebuttal?
Certainly. 5 and 1 and 6.
Thank you.
Bruderman Brothers versus Goldberg is submitted. Gibbons versus a la carte restaurant. Appellant?
For appellant, Jack Mackin. Good afternoon, Your Honor.
Good afternoon. 8 minutes. Respondent?
Joseph Oliva for the respondent, Your Honor. Good afternoon.
Good afternoon. 8 minutes as well.
Thank you.
Nation Star Mortgage versus Osland Loan.
David Scheitelbein on behalf of the plaintiff appellant Nation Star Mortgage, LLC.
5 minutes.
May I reserve 2 minutes for rebuttal?
Certainly. 3 and 2.
Thank you, Your Honor.
And respondent?
Tom Gadara of Oric Harrington for the respondent, Aquin Loan Servicing.
5 minutes.
Thank you.
People versus Wayman Paskins, submitted. Jackson versus New York City Department of Education, submitted. St. Nicholas versus Republic Investment, submitted. People versus Kevin Bryce, submitted. Cordero versus 1278 Minimart. Appellant?
Andrew Zajac for the appellant, Your Honor. Could I do 5 and 2?
I think that's what you have.
Okay. Thank you, Your Honor.
Respondent?
Robert Washuta, Your Honor, for the respondent. 5 minutes, please.
Yes. Akel versus Gergardi, excuse me. Appellant?
Barbara Goldberg for the appellants, Your Honor.
5 minutes. It's submitted as to the respondent.
Thank you, Your Honor.
I'm not going to get this right. Yangbison versus Finkelstein, submitted. Sutton Gate Holdings versus Lacknan Management, submitted. So the first case for argument is Ioannis versus Stybreck. I just want to remind the attorneys, please keep your mics muted until and unless you are speaking. Also, please do not speak over the judges, especially in this virtual world. It does become a real issue. Okay. So as I said, Ioannis versus Stybreck. Whenever you're ready.
Good afternoon, Your Honor. Can you hear me?
Yes.
Hi, good afternoon. May it please the court. My name is Adenine Medina from Vigorito, Barker, Patterson, Nichols, and Porter on behalf of the appellants, Dr. Steinbreck and Gotham Plastic Surgery. The issue on this appeal is the details that the record demonstrate where the plaintiff's willful and contumacious conduct is palpable. It shows a pattern and a purpose of concealment of records that are directly relevant to his claims. It is clear from the very beginning that plaintiff intended to preclude the defendants from access to any records predating his surgery at issue in this case from December 3rd, 2015.
Counsel, this is Justice Gonzalez. To the extent that some of these physicians that were seen by the plaintiff, or is it vice versa, if they were consultations, would that be relevant?
If I understand your question correctly, is whether there's a distinction between consultations versus just seeing the physician?
No, treating.
Versus treating, I'm sorry. There is no distinction in this case. The demands were for any physician the plaintiff had seen. And in fact, the intentional concealment was visible by the deposition of the plaintiff. If you look at page 148 of the record, the plaintiff was asked, did you see any other plastic surgeons? The question was not, did you consult?
So counsel, if I can be a little more precise, if there was a consultation and nothing more, how is that pertinent to your preparation for trial, or how is it relevant to your needs?
Oh, absolutely directly relevant, because the claim here is, according to plaintiff, he did not ask Dr. Steinberg to place the position of the scar or the incision where he did. The record suggests that he had been essentially shopping around for a plastic surgeon that would place the incision where he specifically wanted it. Some of the records that we were able to ultimately receive show that he did have specific conversations with the surgeons that he saw or consulted as to the location of the incision. So if he did see these surgeons consulted even without treatment, the records would show the conversations that were had as to where the position of the incision would have been. And those physicians or surgeons that he ultimately that we were ultimately able to see the records, which he consulted with but not treated, have extensive documentation of the discussions that were had as to the specific location of the incision, which is directly relevant to the issue here as to the claims that he's making that Dr. Steinberg did not tell him where the incision would have been.
So
I don't understand.
I'm sorry, Counselor, did the discovery statute, does that allow you to obtain authorizations for any physician that he consulted with, meaning that he just went and spoke to concerning the procedure?
Of course, the statute says I'm entitled to anything that's material and relevant. And if the issue here is whether or not the provider and the plaintiff, the defendant and the plaintiff, discussed the position of the incision of the surgery, and that was discussed with the prior consulted surgeons, absolutely directly relevant, because it goes to his state of mind, his knowledge as to where the incision was, as to whether or not he requested the specific location of the incision, and that's directly relevant to the issue here. And it's shown by virtue of the records that ultimately we did receive of at least one surgeon that was an extensive point of discussion with that prior consulted surgeon. That surgeon didn't treat, and I'm using the example of Dr. Diza, is a doctor that he didn't ultimately have surgery with, but the records show that the consultation were directly on the issue of where the incision would have been. And that's the issue in this case, the location of the incision, the location of the scar. So under the statute, absolutely, it's relevant.
So was this brought to Justice Rackauer's attention in terms of why you wanted the records as to the consultations, why you wanted authorizations as to the consultations?
This was, there were two prior discovery motions in which we said, we need these records. We don't have the records. There were at least, I believe, 3 or 4 compliance conferences in which we discussed we need prior records. We don't have them, and we don't know what we don't have because he won't give us even the names of these surgeons. So
I think Justice Mazzarelli, did you have a question?
I have a question.
Yes, I did, but let Judge Mendez go first.
Didn't you, in fact, ultimately get authorizations to obtain the records from those physicians that you had requested authorizations from? And weren't those authorizations also initialed to allow you to obtain his mental health records?
So we did receive ultimately for records for Dr. Diza, Dr. Angelchik, and Dr. Guerra. According to Dr. Diza's records, plaintiff had seen in addition, other 8 surgeons of names that we have never received. So we are not able to ask for specific named physicians of names that we don't have.
Didn't plaintiff provide you with authorizations to obtain records from those physicians? Didn't the plaintiff mail you on November 27th, 2018, authorizations to obtain records from those very same physicians that you had previously requested?
As I said, from 3 surgeons only. It is our position that there are additional 8 surgeons that we have never received any records or plaintiff has never identified. for which which are still outstanding. We have never received the names, we have never received authorizations, and obviously never the records.
So the letter that's on in the record, on pages 655 to 667, wherein the plaintiff sends you authorizations to obtain records from I have here 12 providers, Dr. Punia, Phoenix Lab Corp, Dr. August, Dr. Khan, Dr. Tuwani, Dr. Gosi, Dr. Grammans, Banner Hospital-based physicians, Dr. Jou, Jou, Jones, Bolin, and Banner Thunderbird Medical Center. You never got those?
We received those authorizations, but those authorizations were not for surgeons. Those were names that we identified using other records, not names that plaintiff gave us. These are names that we discovered through other records. We did get those authorizations and we did pursue those records, but those records did not pertain to surgeons, which is what it is at issue in this case. We're looking for plastic surgery consultants' records prior to Dr. Steinberg's surgery, which go directly to the issue in this action, which is what did plaintiff know, or what was plaintiff's expectation as to where the incision would have been located?
Yes. Judge Mazzarelli?
Well, yes, I had a question about that point. I don't understand how their material, even if he did discuss where the incision would be with respect to Dr. A, that doesn't prove that your client actually discussed the issue with him in terms that made it possible for him to decide. I'm not sure I understand the materiality of these people who, in the end, did not treat the plaintiff, what they discussed or didn't discuss with the plaintiff helps or hurts what your client allegedly discussed or proves what he discussed with them.
Well, absolutely, because it goes to plaintiff's understanding. Plaintiff testified, and it is his position, that he was not expecting the incision to be where it was. He claims that he had a conversation with Dr. Steinberg that the location of the incision would have been right below the belt line, where other records suggest that he was shopping around for surgeons who were.
But so what if that's what if that is what your doctor told him, then that's an issue in this case. What difference does it make what the other doctors did or didn't tell him? I don't understand. Well, I don't understand your how you get from A to B here.
Well, one, it goes to his credibility, because
how does it go to his credibility?
He's saying that that it was never his understanding that this is where the incision would have been.
Well,
yet
maybe your client didn't explain that to him. It's possible, that's
again proof. That would be a matter of issue at trial. But if you have records where plaintiff has expressly requested to other surgeons, as he did to one specific surgeon that we do have in the record, Dr. Deza, he said, I want my incision to be in a specific location. And now he's saying, no, that's not what I said. That's not my understanding. It goes to his credibility. It goes to the understanding between the parties.
So you're saying that your client would disregard what the medical or correct surgical practice would be because the plaintiff stated that he wished to have the incision at a certain place?
Absolutely, I would not say that. What I would say, though, it goes to consent. It goes to whether or not he was advised as to, the different options. But
as Justice Mazzarelli stated, it does not state whether or not exactly what your client told the plaintiff prior to actually making the incision and prior to the surgery. Just because the plaintiff stated, I want the incision to be a certain place, does not mean, it doesn't tell us what your client told him, nor does it mean that your client should have acceded to the plaintiff's wishes, regardless of what the surgical consequences would be.
Well, two points to that, Your Honor. One, it goes to his credibility. It goes to his state of mind upon his consultation with Dr. Steinberg. It goes to whether or not he chose to consent to the risks associated with the location of the incision. If he had a conversation with Dr. Steinbreck, as he more likely than not had with many other surgeons, he would have been explained, I would assume, this is where the—
Well, that's the problem, counsel. We can't assume, but we'll hear from your adversary now. Thank you very much.
Thank you, Your Honor.
May it please the court. Christopher Dennis, Associate Attorney at the Law Office of Todd J. Kroner for the respondent plaintiff, Michael Ioannis. Your honors are exactly right. These questions concerning the materiality are on point. These prior consulting records do not have an effect on whether or not Dr. Steinbreck was later negligent in his treatment of the respondent. Regardless of what any of these prior consults had said concerning the incision line, does not absolve Dr. Steinbreck from having to uphold the standard of care that's applicable to him as a surgeon.
Did the court order you to produce those authorizations?
No, Your Honor. The very first request that came from the appellants literally said for authorizations for treating physicians. That language was actually in there, and Your Honor was right about the consults not being material. But in addition, the appellants didn't even ask for consults. The whole issue of consults came from a discovery request that the appellants first propounded for the first time after discovery had closed and after the note of issue was filed. And from that, the appellants say that respondent was supposedly willful and contumacious and non-complying with discovery from a belated request. Nonetheless, even though that request was belated, the respondent did in fact comply with that request and did, as Your Honors point out, provide authorizations for those doctors which appellants asked for.
But I think appellants are also arguing that a lot of the names of individuals that he may have consulted with or may have been treated by, that they were able to glean those names and find those individuals from the authorizations that were previously given to them. So they're stating that when asked about those doctors, that your client did not respond affirmatively or denied or stated that he did not remember, and then they subsequently were able to find the names of these individuals, of these doctors.
Yes, Your Honor, I do understand that, but that goes to show that the respondent was not willful or contumacious. And the reason is, during his second deposition, the appellants presented him with his handwritten notes, his handwritten intake notes from Dr. I believe Deza. The appellant's counsel said they could not interpret the handwriting, which was in the respondent's own handwriting. The respondent actually deciphered his handwriting for
But counsel, let's just be clear here. There's been a lot of non-compliance on behalf of your client, hasn't there been? There were 6 compliance orders that basically repeated the same or directed the same disclosure, and that wasn't done forthrightly. So I hear what you're saying, but I don't think your client was exactly cooperative here. There were denials and there was non-compliance.
The discovery compliance conference orders, none of them had said for the respondent to disclose the consultant surgeons.
Is it your position that at this point in time, the names of the consulting physicians have been disclosed?
Yes, Your Honor. Every single one of them has been disclosed. What the appellant's counsel—
Be they plastic surgeons or mental health practitioners of one sort or the other?
Yes, Your Honor. They have all been disclosed. The appellant's counsel's—
And then, excuse me if I may, and have you provided authorizations for each and every one of those persons?
Yes, Your Honor.
And they were properly initialed? Because if I recall correctly, there were authorizations that weren't initialed, so they were useless.
No, they were not useless, Your Honor. The initials were relevant to what was Section 9A, and that is only a subset of the medical records that allow the provider to disclose mental health sexually transmitted disease and substance abuse records. That was not initially initialed, but when the appellants asked for it and it was heard by Judge Rackauer, the respondent did provide new authorizations with that section initial. But
so counsel, to be clear, it's your position that all consulting physicians as well as treating physicians have been disclosed and all authorizations pertaining to those persons have been provided?
Yes, Your Honor. All of the providers have had their authorizations signed and submitted to the appellants. The appellants referred to consulting surgeons, about eight of them, I think appellant said, that she believes was not disclosed. This comes from a letter.
Counsel, let me stop you there then. Have you provided the names of those persons?
Those persons do not exist. It came from a letter that Dr. Deza wrote that referenced 11 prior consultants. That was inconsistent with Dr. Deza's own records, which showed that there were only 3, one of which had been disclosed. In the other,
have you made an affirmative statement to your adversary that those persons do not exist?
Yes, we have, Your Honor. Yes. The standard of review on appeal is abuse of discretion. The appellants cannot show an abuse of discretion where they don't address Judge Rackauer's 11-page opinion and order. This court, in the rare case that it actually reverses a trial court's use of its discretion, has typically been in situations where there is more or less an abandonment of the litigation. That has not happened here. By contrast, the respondent has appeared for 3 depositions, has appeared for his independent medical examination, and in total has provided 32 provider authorizations to the appellant. This is not a case that shows willful or contumacious conduct. This is a case that shows substantial compliance, and the appellants have not shown that Judge Rackauer abused her discretion in denying their request for the drastic sanction of dismissal.
Thank you, counsel. Any additional questions? Thank you very much. I must apologize. When I called the calendar, I neglected to call Vitamin Realty versus Time Record Storage. I do apologize. Each side was assigned 5 minutes of argue time. But again, my apologies.
Your Honor,
next matter for argument is matter of Donique. Whenever you're ready. And Ms. Medina, is that you on this one?
No, it's Marcia Egger.
Oh, there you go. Thank you.
I'm sorry. I keep forgetting about the, do you see me as well? No. Let me see.
No, but so long as we hear you, that's all that really matters.
Here I am. For my client.
There you go. We can see you now.
Okay. As alleged in the motion, the order to show cause for contempt, and as the JHO found in this case, the ACS and the its delegate agency, Graham Wyndham, were unable or did not take any care to fulfill the mandates of the judges of the JHO's orders that require.
Well, here's the problem, counsel. The order apparently was rendered on April 30th, 2018. And then your client turned 21 on May 9, 2018. So we're talking about, really a couple of, less than a month. And also, so under the statute, excuse me?
I'm sorry, you said less than a month from,
April 30th is when the order was signed, and your
right?
client's birthday was May 9. So that's
Right.
less than a month, right? Okay.
Yes, but
And
there were
so-
prior orders.
So
April
the
30th.
point, first of all, we have a short period of time. We have a short window when ACS was supposed to accomplish all of these goals. But not only that, the actual motion was filed after your client's 21st birthday. So we do have an issue as to whether or not family court maintained jurisdiction over your client, given the fact that he was 21 and therefore arguably would no longer fall under the Family Court Act.
But this was a contempt motion, and a court of record like the family court has the power to enforce its own orders, and it's not dependent. Judiciary law does not say that it is dependent on the age of the person. In addition, he was also under the supervision of ACS because he was in an ETP now called CCS 21 Plus program, where he was to continue to get services after his 21st birthday.
But I thought that that program specifically stated that wherein an individual could be placed in that program, the continuation of care and support beyond 21 program, that in no way conferred upon family court continuing jurisdiction over the individual.
But my point is that you do not, the court itself has inherent power to enforce its own orders. It is a court of record. Under the judiciary law, it can entertain a contempt motion, and it is not part and parcel of that contempt jurisdiction that he has to be, that the plaintiff has to be a certain age. In addition, this court and others have repeatedly held that when the initiating process or event predates the child's birthday, that would be a termination of care, that it's still a valid to hold the agencies responsible. And this court did that in a case in 2017, I believe it was. But the larger issue is that the behavior of the agencies was so negligent, so pathetic.
Counsel, if I may. So sure. What about the section of the Family Court Act 1088 that says that the jurisdiction of the family court ends, or let me change that. It continues until the child is discharged from placement, and all orders have expired. So don't we have a problem here?
No, I believe that under the contempt, the power of contempt is not dependent on the age of the person who's bringing the contempt.
But the motion for contempt is brought in the fall of 2018.
But the orders.
In a situation where the order is dated April of 2018 and the birthday occurs, as my colleague indicated, in May.
Right. No doubt about that. But the orders that were not being obeyed is like an ongoing, continuing saga that they were supposed to be doing things and they were never, they wound up screwing up so badly that his NYCHA case was closed for 5 months. That was the period that the judicial hearing officer used as the basis for making her award, for finding contempt and making her award. The fact that he was still, the poignancy of the transcript in which he's saying, oh, I'm almost out of time and nothing's been done for me. And the judge, the JHO was compassionate and making the representations that of course people were going to continue to help him. Well, whatever they were trying to do, it turned out that over the course of those months between April and October, they the agency and ACS were woefully negligent and just, you know, like that whatever they did without any kind of desire or expertise. And they wound up causing the problem where my client's NYCHA application was closed and he had to.
But it was ultimately, we were talking, there are three issues. It was a NYCHA application, it was the passport, and it was the driving. My understanding is that he ultimately was placed on the list for NYCHA housing. There was an application for his passport, and also I don't know whether he obtained his driver's license or efforts were made for him to obtain his driver's license. But my question to you, counsel, is then again, the order was April 2018. When, therefore, are you reading that order would expire? You're stating that order would not expire upon his 21st birthday. When would the order expire? If
the orders that were for ongoing help would be, I think, it would be reasonable to hold them responsible through the period of time that he was in the CCSS 21 plus program through the age of 24, I think it is 24, 25.
And what is the basis for that argument? What's the basis for that position? I'm sorry.
You don't want agencies to be thwarting and not respecting the family court's jurisdiction, its power to order certain things. It makes it a mockery.
Well, I may totally agree with you on that point. My question really is, what basis do you have in the statute or any other relevant case law which would allow us to hold them responsible until you're saying until they complete that program or until they're no longer within that program, which again specifically says that it does not confer upon it family court jurisdiction.
But the jurisdiction arises from the contempt that was based on orders that were valid and were disobeyed and that caused harm. There's no doubt about any of those things. You're saying that there's no remedy. You would exclude a remedy when the remedy is contempt, and contempt is not dependent upon the age of the person who's bringing the contempt.
Ms. Egger, ordinarily in a contempt proceeding, we have an opportunity for the alleged person that has committed the contempt to purge. Now, Justice Weber,
to what?
To purge the contempt.
Oh, purge, right.
Justice Weber has just listed all of the things that were accomplished by ACS. And from looking at your brief, you don't dispute that those things were done. So where does that bring us also?
The only thing I'm disputing is he did get a passport. They did eventually give him driver's lessons, just 4, arranged for that. But he was kicked off the NYCHA list. His application was closed. That did not get purged. There was nothing.
According to the ACS brief, he got an apartment.
He got an apartment with the program New York 3, which is not the same as NYCHA, not as good as NYCHA. And the apartment that he got, he is eligible to stay there, not indefinitely as it would be with NYCHA, but has an age limitation on it, and is not the same remedy, does not purge the failure to take the minimal steps and not difficult steps necessary for maintaining his status on the NYCHA list that he'd had already and lost.
Counsel, did the April 30th order say that all prior orders were to continue until?
No, it did not.
Until the birthday?
Oh, till the birthday, yeah. I'm sorry. It did not say beyond that. You're right. It did not. But the contempt arose out of those orders, and you want the family court's orders.
But counsel, can you have a contempt of the orders expired?
The orders anticipated continuing actions that were not taken.
Thank you, counsel. You have a minute on rebuttal. We hear from ACS.
Good afternoon, Your Honors. Assistant Corporation Counsel Deborah Wassell for ACS. As Justice Weber already pointed out, the family court's jurisdiction is expressly limited by statute to children under the age of 18.
Well,
and then between.
If I may, counsel, what's the remedy here for someone that the court orders certain services to be provided and then ACS doesn't do it? What's the remedy for that person if they become, past the age that you're alleging?
The family court doesn't have jurisdiction after 21, so there is no, contempt is not an available remedy.
What is the remedy?
I'm sorry, Your Honor?
What is the remedy?
In this case, there was no violation of an order because there was no valid.
What is the remedy for someone who, in your view, has aged out? What is the remedy for that person if ACS has just not done what the family court has directed it to do and just has sat on their hands waiting for the person to pass the milestone birthday? What is their remedy?
Okay, well, Your Honor, that's not what happened here, but in that situation,
Counselor, here's how it works. You're asked a question, so you respond to the question. Whether you believe whether that question is relevant or not, that's not up to you. That's up to us. So would you like us to pose the question to you for a third time, or did you understand it the first time?
I understand, Your Honor. My apologies. The remedy for an issue with an agency determination is an Article 78 proceeding. But in this case, there has to be a violation.
This is not an agency determination position. This is a situation, and I'll try and be as precise as I can and as clear as I can. The family court ordered certain services to be provided to this young man. ACS did not provide those services prior to the milestone birthday that you assert divests the family court of jurisdiction. So what is the remedy for this young man against ACS?
Well, Your Honor, that's based on a factual misunderstanding of the record. ACS did provide all of the services up to this young man's 21st birthday. The orders required ACS to help him with his supportive housing application, with his NYCHA housing application, along with the other things that we're not really discussing today. ACS did both of those things. His supporting housing application was put in, and in fact, he's in supportive housing now.
So wait, you're stating that the supportive housing application we're talking about from NYCHA, is that correct?
No, Your Honor, I do want to correct the record because I think there's a little bit of confusion. Supportive housing and NYCHA are two completely separate and distinct things. Supportive housing is not through NYCHA. Donique has housing right now through supportive housing. That was an application that was done, completed, and granted. There's a separate application to be placed on a priority 0 NYCHA housing list. That application was also done, and he is currently on the NYCHA priority 0 application list. He does not have an apartment yet, but that's controlled by NYCHA. That's not something.
So, Counsel, I just want to back up for a second because I want to be clear as to exactly what the order says. According to the record, the family court orders dated April 3, 10, and 30th, 2018. They stated that ACS you were supposed to ensure that he remained on a priority status list for his NYCHA application, that you assisted him in seeking permanent status through NYCHA, that you assisted him in obtaining I'm assuming New York State driver's license, as well as a passport. So you are stating now that ACS did all of these things or made attempts to complete all of these tasks as per the order. Is that what you're saying?
Yes, ACS did do all of those things. And in fact, the family court made a reasonable efforts determination in the April 10th order that ACS had done these things and was continuing to do these things. The orders then expired on May 9th. it's undisputed. All of the orders, both by their terms and by statutory jurisdiction, expired on May 9th, which is Donique's 21st birthday. So up to that point, ACS had been complying with those orders. There was a period of time, it's unclear exactly when this happened, sometime in September or October later that year. This is several months after the expiration of the orders. There was a letter that was not submitted to NYCHA, and that's ACS concedes that was not done.
And in terms of the driver's license, well, it says that you failed to assist him in obtaining his passport, and then in terms of the driver's license, it states that he was residing in a facility in Westchester County, and you signed him up for driving lessons in Queens County, which, as we know, geographically is an issue, and did not provide a transportation plan for him.
So when he presented that to the agency, he was transferred to another driving school that was closer to his home, and that actually was done while these contempt proceedings were happening. So there's no question that he was transferred to another driving school. That was accomplished. His passport, as I understand it, has been obtained. There was some difficulty.
Well, we're talking about during that period of time. What I do not understand then, if in fact, as you're stating, all of these goals were accomplished during that period of time, I don't understand then why did the JHO find differently? Did you not present evidence, documentary or otherwise, to the JHO showing that you did in fact accomplish the goals as set out or ordered by those by the family court orders?
So the JHO's determination appears actually to be based on somewhat of a misunderstanding of the record. It was presented in the affirmations below that Donique had been taken for his passport, that appointments had been made for his passport application, that his driver's education course had been, he had been assigned to a class that was close to his house. All of those things were presented to the JHO. The JHO appeared to make a determination that the time that his NYCHA application was either suspended or delayed, that was attributable to ACS. The time period in the order is incorrect. They base it from, I think, October to February. His status was restored in January. It was January 8th of 2019, I believe was the date that his NYCHA priority status was granted. So to the extent that the JHO based its decision on those things, that's not correct. And actually the family court, in rejecting the JHO's decision, pointed that out, that actually Donique had received most of the things that he was, that he had alleged ACS had failed to do. So,
Counsel, I'm sorry, your time is almost up. I just wanted to ask, just for my own information, the program that he was placed in, the extended continuation of care and support beyond 21 program, is that automatic, or is that something that he would have to apply for, or somebody would have to apply for him for admission to that program?
It's not automatic. He would have to apply, and that application was put in before he turned 21. And that's something that I believe the youth have to continue to apply for on a continuing basis every 3 or 6 months.
Thank you. Any additional questions? Thank you. Ms. Egger, you have 1 minute.
Yes, I just wanted to point out the case of matter of Sheena B. From this court 2011, where the family court was held to have jurisdiction to adjudicate an in petition that had been filed before the child was 18, but the child was now past 18. And this court said, in matters involving the welfare of a child, not only the parties to the action, but also the public has an interest in the continuation of the proceeding. Thank you.
Thank you. Any questions? Thank you very much. Thank you both. The next matter for argument is Gibbons versus a la carte restaurant.
Good afternoon, Your Honors. For appellant Edmund Chakmakian, may it please the court. The lower court was not faced with the type of case that comes near to the, quote, extraordinary circumstances, end quote, that this court has repeatedly held would warrant a sua sponte dismissal. Usually when there's a sua sponte dismissal, one party is asking for relief And the lower court says, no, not only are you not going to get that relief, such as summary judgment, but even though the other side didn't ask for it, we're going to grant that relief. In this case, neither the appellant nor the respondent asked for the relief of a la carte being dismissed. The courts have repeatedly held.
Well, excellence. It was excellence that moved for dismissal, right?
Yes, Your Honor. The case was against a la carte as the operator of the restaurant and the builder who had recently undergone renovations. At the end of discovery, the builder, excellent builders, moved for summary judgment. After seeing their argument, both myself and counsel for a la carte agreed that there was no prima facie case made out, and we did not oppose it. A la carte did not file a notice of motion and did not move at all for summary judgment. And the cases are legion that basically say there has to be extraordinary circumstances. It's very sparingly used.
The judge stated that he searched the record, and that in searching the record, he found that the same issues as to excellence also were prevalent or related to a la carte or Carmine's.
Well, here's where we believe he was wrong, Your Honor. He references and he walked through the bill of particulars, but he makes no reference to the second supplemental bill of particulars, which is on page 104, pardon me, of the record on appeal, where we supplement the bill of particulars and state that they failed to provide proper and adequate lighting in the area where the accident occurred. Ms. Gibbons testified clearly at her deposition when asked about the lighting at page 147, question, line 11, what were the lighting conditions like in the restroom? Answer, it was rather dark. I would say it was poor. There are many, many cases that hold that a layperson can testify as to the adequacy or lack of adequacy of lighting, even in the labor law context where it has to be 10-foot candles and there's no exact measurement. A layperson, such as a construction worker, can testify about the lack of lighting. She also
said that he noted that there had not been any prior complaints about the restroom, no mention of water on the floor. She claims that she slipped. No mention of water on the floor, that the restroom was checked, I think at least every half hour, it would be mopped. There would be a sign, no indication of any violation of any rule or regulation, which I would think goes to the lighting issue.
Well, Your Honor, there's no rule per se about lighting. They have a common law duty to provide adequate lighting. She does go on to testify that she did not see the water before, presumably because of the lack of lighting, and she doesn't see it until she's on the floor and her jeans are soaking wet. So they were in exclusive control of the ladies' room, and their duty to provide lighting is not a statutory one or a regulation or a code.
Isn't your real complaint here that you didn't have notice that you were going to have to defend these arguments?
Well, absolutely. We were not on notice whatsoever. You know, I concede that the lower court can search the record and do this, although it's exceedingly rare and done very sparingly and I'm quoting the case law now, under only the most extraordinary of circumstances. Had a la carte moved, had I been served with notice, and they made out what they thought was their prima facie case entitling them to summary judgment, I would have opposed just along these lines, saying that no, we pled that there was lighting. She discussed that at her deposition. It is a substantial factor in causing her accident. I don't have to plead a regulation or a code violation. It's a common law duty to provide lighting. The cases are.
And you were not allowed, or you did not make these arguments because you were unaware of the motion, that the motion would be made as to, or granted as to a la carte as well, because of the lack of notice. Is that correct?
Of course, it wasn't even noticed because they never asked for it. I'm pretty sure they were surprised as I was.
Any other questions? Thank you very much, Counselor.
Thank you.
Good afternoon, Your Honor. Joseph Oliva for the respondent, a la carte. I think counsel in his arguments made some good points, which I'd like to address. You know, he talks about what the record states, about what his client testified to, about lighting, about the fact that she said she was soaked in water after she fell, and she saw the water after she fell. Well, that goes right to the heart of the sua sponte power that the Supreme Court of the state of New York has. It has the ability to search the record. has the ability to look at all the testimony.
Counselor, the party against whom that relief is being sought has the opportunity to be heard.
If everybody could please mute your mics.
Judge Mazzarello, I'm sorry, I missed that.
I said that he did discuss those issues. However, the party against whom the relief is being awarded, something is.
Yeah, please, everyone mute. Is everyone on mute?
The plaintiff's attorney had the opportunity to know what was going to happen, that there was going to be a search of the record, and that your client's case was going to be determined. Case against your client was going to be determined. And he didn't get that opportunity to respond.
Well, I think, Judge, and I understand what you're saying. I think in this case, because all the deposition testimony was put into the record by Excellent, including plaintiff's deposition, Mr. Yao's deposition, Mr. Hayes, Ms. Guzman, Mr. Dugan. The judge indicated in the transcript, which we put in with the supplemental record, that he read all the papers submitted by Excellent. He actually looked up all the code violations that were articulated in the bill of particulars, read all the depositions. There was no complaints about the water. There was no mention of the water, for instance, in the incident report. Now, while the incident report
the judge here, to me, you're describing the judge acting as a fact finder.
Well, I think, Judge, all the facts were before the court, and the court made the determination. The very arguments the plaintiff has been making with respect to this were actually in the record before the court when the court decided the motion in favor of my client. And the fact that it went through all of that, looked up the violations, considered all the testimony, including plaintiff's testimony, which talks about the lighting, talks about when she first noticed the water. I think the court had the right, and I think appropriately, determined sua sponte on the record what these issues were. I mean, what else could the plaintiff have argued other than what he just articulated here, which was already in the record before the court? Now,
how about due process?
I'm sorry, Judge?
How about the concept of due process, that each party is entitled to the right to be heard?
And I think the court, and Judge, I understand. I think the plaintiff had the opportunity to be heard and chose not to put opposition papers in, first. And second, everything he was going to argue was already before the court in the very record that the court decided this application on. Now, I understand the court uses this power very sparingly. And I know the cases are not as consistent as I think we all would like them to be. But I think where appropriate, the sua sponte power is justified, and I think it was appropriate in this circumstance.
You don't see a possible difference between the arguments made by Excellence as opposed to arguments made by the premises by a la carte Carmines in terms of liability?
Well, Judge, I think there are some slight differences. Obviously, we have a contractor who finished work 8 months before this accident, and we have the owner of a building. I think there's one argument that is very consistent with both defendants, and that's the notice argument. And right now, based on this record, the court seemed to find, and I think I've found based on the testimony, that there was no notice to the building owner as well.
Well, that goes back to the lack of notice and due process, because perhaps those arguments as to the notice element, et cetera, could have been fleshed out by a la carte / Carmine if they had notice, obviously, of the motion.
Oh, Judge, I think you meant the plaintiff could have hashed that out, not a la carte.
I'm sorry. Yes, that could have been hashed out by the plaintiff if they had notice of what was notice of the motion. Thank you.
Right. No, Judge, I understand that. And I think...
Justice Mazzarelli, I'm sorry, did you have another question?
I couldn't hear what was said.
Did you have another question?
I was just going to point out that counsel made reference to the deposition testimony. During a deposition, the person being deposed only responds to the questions being asked. So it's not a full examination. And there is no cross-examination, I'm sure you are aware of this, Believer.
Judge, I presume you're referring to plaintiff's testimony.
Yes.
Well, you're right.
Any party's testimony.
Well, that's true. It's a cross-examination by the party who's conducting the deposition, as we all know. I think, but the fact that the questions were asked, I think her testimony is pretty clear about what she believes she slipped on, and about the lighting in particular. I think that goes right to the heart of what the issues are with us in this case. And I think the court considered all those issues in rendering its decision.
Thank you. Anything further? Any additional questions? Thank you very much. Thank you both.
Thank you.
The next matter for argument is Nation Star Mortgage versus Ocean Loan.
Good afternoon, Your Honor. May it please the court. I'm going to focus my argument this afternoon on the IAS court's dismissal of the first and third causes of action, and to the extent time permits, the $1,000 loss threshold set forth in 6.04.
Well, would you mind changing your focus for a minute if I have a question?
Absolutely, Your Honor.
Thank you. My question is, what are we doing here with this appeal? This is an appeal, the dismissal of a complaint. Am I correct?
That is correct, Your Honor.
You've served an amended complaint, and there's been a motion to dismiss that amended complaint. It's sub judice. Why are we looking at the complaint when there's already been an amended complaint served?
Well, Your Honor, the case law is such that as a matter of belt and suspenders, the parties and we submitted an amended complaint, but we stand that if we did not do so, we risked actually waiving arguments on appeal. We did not.
I'm not criticizing you. I'm saying, do we have a role here? I mean,
yes, Your Honor, you absolutely have a role here. We did this as a belt and suspenders, and we did not waive anything, and this court is in a right to decide this motion.
But what are we deciding if you've already served a new complaint? That's the operative complaint now.
No, what you are deciding are the issues that were raised below, specifically the issue of future losses and the issue of the dismissal of the indemnification claim. And in fact, if you look at defendants' arguments, the only thing that defendants or Ocwen argues mooted was the specificity with which 3013 was pleaded. They do not say that the arguments with respect to the future losses or with respect to the dismissal of the indemnification claim as duplicative was dismissed. So against that backdrop, Your Honor, the court's Nation Star versus Generation decision that came down last month is directly on point, controls, and reaffirms what Nation Star has argued all along. So long as Nation Star properly noticed its claims for indemnification within the survival period, nothing in the purchase agreement limits Nation Star's recovery to losses suffered before the survival period.
Aren't you limited by the agreement set forth in 606 that you have to have specific pending claims and the losses also have to be more than $1,000?
Yes, Your Honor, and we provided specific notice of those claims prior to the end of the survival period. And the way that 6.06 works is
with dates, with dates to indicate when those claims accrued.
Well, Your Honor, the notice requirement in the contract does not say anything about dates. It just says notice of those claims. And as
so how does someone determine whether they accrued before the purchase agreement or after the expiration of the purchase agreement?
Well, whether or not the claims accrued before the purchase agreement or after the purchase agreement doesn't matter. We gave notice of the claims consistent with the requirements within the contract. We gave that notice before the survival period, and the way that 6.06 works is once that notice is provided to Ocwen, the survival period no longer applies to those noticed claims.
And these were actual losses?
That was
these. We noticed
or future losses that you contemplated could happen.
The notice was for both. We noticed actual losses, but we also are entitled to, and under the progeny of generation, we are entitled to recover all losses.
But the agreement limits you to actual losses, right?
No, the agreement.
Actual out-of-pocket losses, damages, deficiencies, claims, costs, or expenses. There's nothing there about liabilities, right?
No, what 6.06 provides is that all we need to do is provide notice of the claim. And claim is much broader, and notably, it does not say notice of the losses. What defendants have done is read losses into what we have to give notice of. Just like in generation that was decided last month, we gave notice of the claims. Once you give notice of those claims under 6.06, the cutoff, the survival period no longer applies.
Did you make claims as to monies owed less than, let me just change that, losses less than $1,000?
Well, the way that servicing works,
because that aggregate formula seems very disingenuous.
Oh, I don't think it's disingenuous, Your Honor. What the contract says is that a loss under the contract under 8.05A of the purchase agreement, terms defined in the agreement have the meanings ascribed to them and include the plural as well as the singular. So what 6.04 in effect reads is that Ocwen shall be liable to NationStar under section 6.01 for only if any and all actual out-of-pocket losses, damages, deficiencies, claims, costs, and expense for which indemnification is claimed exceeds $1,000. And that is exactly what NationStar claimed here, is that across each loan, it is entitled to losses where the losses exceed $1,000. And just to go back to a point that was raised before with respect to the dismissal, the court dismissed the claims with prejudice. And so we had to replete those claims to make sure that we had the ability to continue to pursue them, but that in no way was a waiver of our underlying rights.
Thank you. You have 2 minutes on rebuttal.
Thank you, Your Honor.
Thank you, Your Honor. May it please the court. I want to address a few things counsel just mentioned. The first I think we can focus on is the language in 6.04 regarding the plural versus the singular and the loss claim threshold that's in this contract. I think it's pretty clear from the language itself that only singular losses, a loss for which indemnification is claimed, may be pursued if it exceeds $1,000. The lower court determined as well. I think one thing I want to flag, and counsel has raised the generation mortgage case a couple times, is the contract at issue in that case, which is all very much like this one in that it is a servicing rights sale agreement that was primarily drafted by NationStar. That contract has two provisions in it. One, which is the claim deductible provision, which very clearly shows what it would look like if there were a provision here that permitted the aggregation of losses. The claim deductible provision in that contract, which is 7.02C, shows that it explicitly refers to aggregation, whereas the de minimis loss threshold, which is the one that mirrors this provision in NationStar's standard contract, does not say anything about aggregation and clearly states that each individual claim must exceed $1,000. I think more generally, we need to focus a bit on generation mortgage today. Counsel submitted it for the court's attention as supplemental authority. We tried to file a motion, emergency motion, to get some briefing before the court on that case before today. It's a case that was staggered to occur before this one, I think, in part because it is a case that is very, very different, but if looked at least on the surface, could compel the wrong outcome here. That case deals with reverse mortgages. This case deals with forward mortgages. So all the considerations that would drive the decision by the court in that case with respect to logic and fairness in terms of the assertion of losses and the protections that the parties bargained for and put into their contracts work the opposite way here. And one thing that counsel kind of glossed over and I think was touched on a little bit is that the nature of the difference between those two cases, those two contracts on a key point of the terms loss and liability really drives the decision here and should dictate how we approach whether future losses are ascertainable and obtainable in this case. The generation mortgage case, that contract there refers interchangeably to loss and liability in discussing the indemnity obligations in that contract. It also makes very clear that the only provisions that are to expire at the end of a 5-year period that's in that contract are the reps and warranties. By contrast, this contract is fundamentally different in that the indemnification obligation itself is to expire 3 years after the close, and it contemplates and there's no reference whatsoever to liability, which is an important term of art in the scope of, in the world of indemnification. We touch on this in page 23 to 25 of our brief, and it really drives the opposite outcome from that case and the case Remet, on which counsel relies quite a bit. The reality is, if it is determined that Ocwen is on the hook here for losses that occur or accrue in the future, that could happen 20, 25, 30 years from now, because the mortgages here, being forward mortgages, have a length of upwards of 30 years. Reverse mortgages, having a length of 5 to 7 years, the thinking is reversed. And so in that case, the plaintiff appellant, conceivably couldn't actually understand what its losses were within the contractual repose period. So the notion that it could assert a claim for a liability and indemnity that has a forward-looking effect makes sense. By contrast here, we can see in the complaint itself that counsel asserted a claim for $15 million worth of damages that it says it did suffer within the 3-year repose period, which is a bilateral provision, bilateral protection that both parties negotiated and worked out. If we were to ignore that provision and ignore the protection it's supposed to bestow on both parties, it would essentially make this contract and the obligations between the parties run 20, 25 years into the future, and which would be totally counter to the intent and the letter of this agreement. I think beyond that, I would emphasize that what we're dealing with here is a known universe of losses. It grows out of servicer advances, which are sold as assets in this agreement. Whereas in the reverse mortgage situation, the generation mortgage case, the losses that are to accrue later in time and deal with subsequent servicing. The losses at issue here, the indemnifiable losses at issue here, are losses that in many ways already can track to amounts of monies that were expended prior to the purchase agreement and actually found their way into the purchase price. Plaintiff appellant buys the servicing advances, the outstanding advances, and the right to receive the reimbursement of those advances from the government, and pays Ocwen money for it. And so the indemnification obligation here and the whole structure set up in all of Section 6, from 6.01 all the way through 6.06, contemplates a process whereby, as claims are submitted to the government entity and they are denied, an indemnity can be asserted to Ocwen, and then it's paid. And that process continues for 3 years, and then it is over. And by contrast,
Counsel. Thank you. Your time is up. Thank you very much. Counsel, you have 2 minutes on rebuttal. Could you just respond briefly to your adversary's argument concerning these losses in perpetuity in terms of accruals in the future?
Certainly, Your Honor. The claims already occurred. What we noticed prior to the end of the survival period were the breaches and the basis of our claim. What may occur in the future are losses stemming from those. So the idea of perpetuity is kind of a misnomer. Second of all, defendants' attempt to distinguish generation on the basis of reverse mortgage servicing is just not accurate. If you look at the reasoning of this court's logic in generation, it was based on the unambiguous way that the contract read and what the survival provision provided, not on the nature of reverse mortgage servicing. Second, there is no real factual distinction here between reverse mortgage servicing and forward servicing. They go on for years into the future, and if Ocwen's interpretation is permitted, then NationStar would face a very long tail of potential liability, which is not what it contracted for. 6.06 here is again clear. You have an indemnification period. It shuts off after 3 years, unless timely notice is given. Timely notice was given here, and as the generation court, the adequacy of that notice is not an issue for addressing a motion for dismiss. Lastly, I want to address this distinction that they draw briefly with respect to the idea of liability. The references that Ocwen has and makes to liability have nothing to do with the liability for the actual indemnification. It talks about rather Ocwen and Generation's obligation to indemnify. That is exactly the same way that the Ocwen contract talks about the concept of liability. If you look at the last paragraph of 6.01, 6.01 says and refers to Ocwen's indemnifications to indemnify as a liability. Both contracts read the same. The contract language is almost exactly the same between 6.06 and 7.01 in the generation agreement. The only meaningful difference makes even clearer in Ocwen that as soon as timely notice is given of a claim, once that notice is given, the survival period no longer applies.
Thank you. Any additional questions? Thank you very much, Counselor. Thank you both.
Thank you, Your Honor.
Your Honor.
Cordero versus 1278 Mini-Mart.
Yes, good afternoon, Your Honors. My name is Andrew Zajac, and I'm appearing this afternoon on behalf of the appellant Margol Realty. Your Honors, my client's motion for summary judgment should have been granted. My client was the landlord here, and the accident was caused by an independent contractor who was hired and paid by a tenant. In San Pedro versus Elwood Realty, this court clearly held that a landlord is not liable for the acts of an independent contractor hired by a tenant. Application of this court's holding in San Pedro should result in a dismissal in favor of my client. Further, the motion court was mistaken in holding that Section 7-210 of New York City's sidewalk law extended to this case. This matter simply does not involve a sidewalk defect within the meaning of Section 7-210. As shown in our briefs, the Court of Appeals has held that Section 7-210 is limited to defective sidewalk flags and snow, ice, dirt, or other debris on the sidewalk. Falling metal plates caused by a tenant subcontractor is not a sidewalk defect under Section 7-210. Also, in Hay versus Troom, the Court of Appeals held that Section 7-210 is not an absolute liability statute and that traditional tort principles apply to a claim against the landlord. That being the case, this court's holding in San Pedro should absolve my client of liability. Finally, Section 7-210 should not be considered because it's entirely new theory that was not pled in the complaint or bill of particulars. And for these reasons, I respectfully ask for a reversal.
Any questions?
Counsel, isn't the owner,
Yeah.
sorry, isn't the owner required to keep the sidewalk in a reasonably safe condition?
Yes, against defects such as defective sidewalk flags and snow, ice, dirt, or other debris. The Court of Appeals made that clear.
Didn't your superintendent see the metal plates being unloaded?
Yes, but they were being unloaded. There's no indication that he saw them leaning up against the wall of the bodega. Again, this was the tenant subcontract.
Does the record have any information as to how often the sidewalk was inspected that day?
Well, no, Your Honor. Again, I have to say that this is not a sidewalk defect within Section 7-210. In Vudasovich versus Epsom Downs, the Court of Appeals specifically referred to Sections 19-152 and 16-123 as examples of what 7-210 applies to. And those specific regulations talk about misleveled sidewalk flags and snow, ice, dirt, or other debris on the sidewalk. A falling metal plate that was put up by a subcontractor of a tenant. There's no indication here that there was anything wrong with the sidewalk. Plaintiff wasn't hurt by a sidewalk defect, Your Honor.
Thank you.
You're welcome.
Anything else? You have 2 minutes on rebuttal, counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. Robert Washuta on behalf of Dolores Cordero, the plaintiff respondent in this case. I was going to address things in a little different way, but hearing Mr. Zajak's emphasis this afternoon, I think I'll just kind of address where he seems to be putting his focus. And his focus is to mischaracterize what a landlord's obligation is vis-a-vis maintaining a reasonably safe sidewalk. He seems to think that the administrative code and the case law only applies to what I would conceive as a structural deficiency in the sidewalk, like a missing piece of the sidewalk flag, or a missed level between the two sidewalk flags. That's not the law, and that's not what the administrative code requires. In fact, he mischaracterized 72-10 when he said it applies, to snow and ice. That's not what it applies to. In fact, what he was trying to refer to is the administrative code section 16-123. And even at that, he mischaracterizes it and leaves out the clear language of that particular section of the code, which I'll read for the court when it says, every owner having charge of any building in the city upon the street shall, after the deposit of other materials upon the sidewalk, remove snow, ice, dirt, or other materials on the sidewalk. Other materials on the sidewalk. We're talking about this sidewalk had large floor panels stuck on the sidewalk that impeded a pedestrian's ability to transverse the sidewalk. I mean, according to Mr. Zajac, if in this particular case, if it wasn't the sidewalk panels that were put on the sidewalk, suppose it was the workers, a toolbox where they were doing the work and they put their saws and they put their hammers and their screwdrivers into this box and they left it on the sidewalk, and someone came by and tripped on it because they couldn't see it or it was camouflaged in some way. According to Mr. Zajac, that doesn't apply. The landlord gets a freebie because it's not snow or ice. It's something different. Well, it's material.
And your client alleges that the manner in which the sheet of metal was positioned, secured, or stored constituted a dangerous or defective condition. Is that correct?
On the sidewalk, yes, Your Honor. That's exactly what we're saying. And the administrative code, it deals with that directly, and so does the Court of Appeals. Most recent case in He versus Troon. This is not some artificially limited concept. This is a concept where the courts and the administrative code is trying to protect the pedestrians who are walking on our sidewalks.
So, counsel, your adversary, your counsel pretty much is arguing that there was no crack, there was no defect, and as a matter of fact, he had nothing to do with it because it was the grocery owner who did everything wrong.
Well, Your Honor, that's not really the case. And in fact, what is going on here, it's first of all, his mischaracterization of what I think the administrative code provides for city sidewalks. But there's also a duty here as the owner of the building to keep it in a reasonably safe condition. And this particular owner, it's critical to point out, this is an in-possession owner. They have their super living in the building 24 hours a day, 7 days a week, whose job it is to maintain the building and keep it in a safe condition. This was a project that this super knew about, saw being done, was in and out of that store, saw materials being brought in. He cannot tell us in any stretch of the imagination, as we've said, when he last was there, what he saw and when he saw it. There's a duty there of this owner in this context to ensure that that premises, vis-a-vis these construction materials that were put outside their building, was kept in a reasonably safe manner, that they were properly stored or properly maintained, or not even there in the first instance.
Thank you, Counselor. Any additional questions? No? Okay, Ms. Ecker, you have, looks like 2 minutes on rebuttal.
Okay, I'll be quick. Your Honors, again, there was nothing wrong with this sidewalk. My adversary, who argued extremely well, brought up the example of a toolbox on the sidewalk. Well, there was no toolbox on the sidewalk. There was nothing wrong with this sidewalk. There was nothing.
But Counsel, there were materials there that were not adequately secured and that fell on the plaintiff, injuring her allegedly.
Right, but there was nothing wrong with this sidewalk, Your Honor. It was.
The sidewalk was obstructed. It wasn't in a reasonably safe condition if you accept the plaintiff's arguments.
Well, the sidewalk was not obstructed, Your Honor. The panels were leaning up against the side of the building, and they were put there by the tenant's independent contractor. Your Honor, the landlord has the plaintiff has a remedy here against the co-defendant Bodega, who for some reason is a party to this case and chose not to oppose our appeal. It was not our independent contractor who did this. And if credence is going to be given to this court's decision in San Pedro versus Elwood Realty, a landlord is simply not liable for the acts of an independent contractor hired by a tenant. If there's any case here, Your Honor, it's against the tenant and it's not against my client. Unless the court has any further questions, I would like to just say that I hope everybody that hears my voice stays well.
You too. Thank you so much. Thank you both. Take care.
Thank you, Your Honors.
We have Appellate versus Jagardi.
Good afternoon, Your Honors. May it please the court. I'm Barbara Goldberg. I represent the defendants' appellants. It's our position in this case that based on the plaintiff's own deposition testimony and the records of providers who treated him both before and after the surgery at issue, that his psychological, psychiatric, and mental health records have a direct bearing on the injuries claimed in the action. And these injuries include fatigue, insomnia, difficulties with activities of daily living. Under the decision of the Court of Appeals in Brito against Gomez, and Justice Mazzarelli, I know that you're very familiar with that case, respectfully.
Yes, I dissented.
I think you were actually in the majority in this.
I was in the majority in the appellate division, but I dissented from the Court of Appeals.
Yes. Respectfully, I think that under the Court of Appeals decision in Brito, the court should have ordered the plaintiff to provide unrestricted HIPAA authorizations for his mental, psychiatric, and psychological records. And I think
isn't the reasoning of the court was that he did not place his mental condition an issue in this case, and therefore he should not have to disclose any of his mental health records, for that matter.
That's correct, Your Honor. That is what the lower court found, and that is what the plaintiff argued. However, that's not the end of the inquiry, because we were able to show through his own testimony, through the prior and subsequent records, that his psychiatric conditions, his mental conditions, have a direct bearing on the causation of the injuries claimed in this action. As I mentioned, those injuries include insomnia, they include fatigue, they include a lack of energy, they include a lack of the ability to engage in the activities of daily living.
And so many of these complaints stem not from the treatment, but your argument is that many of these complaints stem not only from the treatment, but also from his underlying mental health conditions.
That's exactly correct.
And also may have predated the treatment because of these underlying mental health conditions.
Yes, Your Honor, that's very clear from the record because the surgery that was at issue in this case was performed in May of 2014, and he was treated at St. Luke's Roosevelt Hospital Center from 2007 through 2010. And many of these same conditions that he's claiming as injuries as a result of the treatment are documented in the St. Luke's records.
Yes, and so contrary to our colleague, Justice Mazzarelli, therefore you're arguing that you are entitled to these HIPAA authorizations. Is that correct?
Yes, that's correct, Your Honor.
Thank you. Any questions, Justice Mazzarelli? Any questions?
Well, I guess I'm in the minority here again.
Thank you very much, Counselor.
Thank you, Your Honors.
And again, I apologize, but I now remember Vitamin Realty versus Time Record Storage.
Yes, Your Honor, thank you. It's David Bowles for the appellants here. Could I go 4 and 1, reserve 1 minute for rebuttal?
Certainly.
Thank you, Your Honor. I'll be quick. Your Honors, the lower court dismissed our claims for breach of contract and for breach of duty of good faith and fair dealing. Our position is that the lower court should not have done so based on documentary evidence or at all. They were well pled, and the documentary evidence certainly doesn't support the dismissal. The background of the case, particularly with regard to breach of contract, has to do with this plot of property in New Jersey. And in late 96, early 97, the original owners of that property sold the northern part of the property to my clients.
So,
Now,
counsel, if I may, we're familiar with the facts in large measure. Can you explain the relationship, if any, between the two agreements, the easement and the crossing agreement, please?
Absolutely, Your Honor, and that is the critical issue I was headed toward. Those have to be read together, is our position, because neither of them makes sense without the other. I want to call the court's attention to this critical thing. There was an easement for our client, Vitamin Realty, to pass over the southern property to get to Long Avenue. And for them to do that, they also had to pass over the railroad tracks, which required the license agreement. There was not a reciprocal easement for the prior owners or the respondents to pass over our property, Vitamin Realty's property, which means that the only purpose of that license agreement for 16 years and more was to benefit the easement. You couldn't use the easement without crossing over the railroad tracks. You needed to get that last 10 feet over the railroad tracks. So the only purpose was to maintain it. They have to be read together. The easement without the license agreement is useless, and the license agreement without the easement is purposeless, completely purposeless. So our position is they were enacted or entered into within 30 days of each other, and we cited the court to the Now versus Vulcan Rail case, which says that in these sorts of circumstances, when you've got intertwined agreements that are designed to serve a common purpose, that they must be read together. The lower court gave no acknowledgement or credence to that whatsoever, and my position is they must be read together, such that in 2013, when the respondents stopped paying the $1,000 to Conrail, they breached the intertwined agreements. They made
Counsel, if I may just ask you a question by way of background. So in the absence of a proper railroad crossing with the light and the bar and so on, is it prohibited to cross railroad tracks?
I do not know, Your Honor, but I know this, that when the respondents stopped paying the $1,000, what Conrail did was pull a gate across the tracks. So it became physically impossible to cross it. And also, by the way, it's worth noting, at one point, as alleged, the respondents barricaded the easement, which is a clear breach of the easement agreement itself that the court should have considered and did not. For 16 years, of which 13 involved the respondents, the system worked well. My clients, Vitamin Realty, paid $2,500 to the respondents, and the respondents passed through $1,000 to Conrail. It was only in 2013, for some reason, that they decided to blow it up and stop complying with the agreements. Our position is that that is a breach of contract. The intent of the parties has to be examined on that, and the lower court gave no credence to it. My second point has to do with breach of duty of good faith and fair dealing, of which I think this is a perfect example. Any reasonable person looking at the easement agreement would have understood that it was necessary to maintain not only the easement and the pavement and what have you, but the license agreement as well. they would have understood that $1,000 of that $2,500 should be passed through, and that the respondents had to keep that license agreement in effect. Otherwise, again, the easement is useless. You can't use the easement unless you can cross a railroad track. Now, my opponent has made the typical argument that you can't add terms to an agreement, and I agree, but implied terms are what are served by the duty of good faith and fair dealing, and they are served here. The only other point I want to make is something, I'm sorry, Your Honor.
I was just going to ask you if you're going to address your arguments regarding the alter ego theory of the defendant TRS.
Yes, Your Honor. My only point on that is that TRS was the entity that my client knew about and dealt with all this time. It turns out there was an entity, 225 LLC, I believe, that owned the property, but Time was always the one that was acting on their behalf. They're the ones who sent invoices for the $2,500, who accepted the checks and what have you. And based on the facts that we pled in the complaint, they share offices, they share officers, and I believe that we pled enough for the veil-piercing purposes to keep Time into the matter. I think that was just simply on the papers, it's properly pled. There's one other point I wanted to get in before my 4 minutes expires, which is my opponent has argued about the terminability of the license agreement in a way that I think is frankly misleading. They have said that so the respondents could terminate the license agreement, and therefore clearly they had a right to do so. That's misleading. The only way that agreement could be terminated was by mutual agreement between the respondent and Conrail. There is no allegation and certainly no document in the record to show that was ever reached. What they did was breach, and then Conrail terminated. They stopped paying the $1,000 per year. Even while my client continued paying them $2,500 per year, Conrail ultimately got fed up and terminated the contract and closed the gate. Ultimately, they did start refusing our $2,500, but what they did effectively was breach the license agreement, which killed the easement, and that was the effect. And I believe that is both a breach of the contracts here that should be read together and a breach of the duty of good faith and fair dealing.
Thank you. You have that minute on rebuttal.
Thank you, Ron.
I don't see the, oh, yeah, you're muted. Still can't. Is he still muted?
Your Honor, I can't hear counsel. I'm sorry.
No, I can't. Counsel, we can't hear you.
You know?
Yes.
Okay. I'm not sure what happened. I'm sorry. My apologies.
It's okay.
May it please the court, Joshua Kapelowitz for the respondent. Your Honor, Your Honors, this entire argument by appellant hinges on the fact of fiction. It hinges on the court accepting that there is an implication in an agreement written 3 years after another agreement. Let me be clear about that. And this was glossed over to be kind. The easement agreement was entered into between Hillside, the owner of the land on the south side, and Vitamin in 1997. The crossing agreement between Hillside and Conrail was entered into in 1994, 3 years before. These were not two agreements entered into at the same time. These are two agreements entered into 3 years apart. And yes, to get across from the south side to the north side, you have to cross 225's former property and the railroad tracks. They knew this. Vitamin knew this when they bought the property. They entered into an.
But counsel, wasn't there an agreement in 1996 that, in essence, referenced that there was going to be a purchase of that specific tract by the plaintiff, and therefore that purchase would be contingent on the crossing agreement being in place?
There is nothing to that, Your Honor.
December 10, 96?
In 1996, there was an amendment to the 1994 crossing agreement.
Correct.
That amendment says we're entering into this agreement, we're entering into this amendment of a 2-year-old agreement because we anticipate selling the northern part of our property, which at one point was 1, and we had a agreement with Conrail so that we get to both sides. We anticipate selling it to part of our property on the north side to Vitamin. And in anticipation of that, what did we do? We stuck in, I'm saying we, but I'm talking as if the former owner. We stuck in a mutual termination provision that Conrail and Hillside could both execute, and stuck in a termination provision in the event that Hillside or its successor failed to comply. So they knew that the piece was going to be sold, or they anticipated it, and they didn't make a provision saying we have to maintain the crossing agreement. They made a provision to allow for the crossing agreement to expire, to terminate, come to an end. So it's the opposite of what counsel is saying. But again, that's of course if you want to look outside of the 1997 easement agreement, which frankly, Your Honor, we say you can't. It has a merger clause.
Wasn't Hillside required to maintain and repair the easement? Maintain the easement?
The easement on their property. The easement's defined as the strip of land cutting through the south side's property. It does not in any way mention the railroad tracks, payment to Conrail, or anything of that nature. It's merely we can only talk about.
And you're saying that the two agreements should be read separately.
They're separate agreements entered into 3 years apart by different parties. There's nothing in either agreement referencing a obligation for the other agreement. Oftentimes what would happen, and if I was Vitamin's counsel, I would have said, okay, we got this, we're going to enter into this easement agreement.
But Hillside wasn't Hillside paying a $1,000 fee to Conrail on behalf of the plaintiff?
No, Your Honor. Hillside was paying a $1,000 fee to Conrail so that Hillside could cross the tracks to its own property. Because let's remember, in 1994, Hillside owned both sides of the rail, both sides of the property on either side of the railroad.
Okay.
But it continued doing it for 16 years.
They continued doing it for a period of time, Your Honor, and it's my understanding they continued to do it for a period of time because there was an understanding that the owner of the south side property was allowed to use the parking lot of the north side property. When that relationship ended and they brought a trespass claim at some point, as you can tell, then there was no benefit to the south side property to maintain the license agreement, the crossing agreement.
Was there anything in writing for?
There's no.
Was there anything in writing that obligated the owner of the north side property to allow the owner of the south side property to use the parking lot?
Absolutely not. There's no writing obligating north side to allow south side to use a parking lot, and there's no obligation requiring south side to maintain the crossing agreement.
No, and then the amendment only said that it cannot be, it needed to be, it had to be a mutual agreement in order for the crossing agreement to be somehow terminated, which that's not what happened here. Because
well, that's not correct, Your Honor. It says
this was a mutual agreement between Conrail and 225 Long or Hillside to terminate the crossing agreement.
It says that in the crossing agreement, just so we're talking about the same thing, the 94 as amended in 96.
Right.
The agreement provides in paragraph 11 that it can be terminated upon mutual consent, as Your Honor correctly points out, or it can be terminated in the event that Hillside/225 fails to comply with the agreement. So if Hillside or 225 did not pay, then it would terminate.
Well, that would be a breach on the part of Hillside, wouldn't it? Exactly. So Hillside breached the agreement, and therefore Conrail barricaded the crossing.
Hillside chose not to pay for an agreement it wasn't using, and Conrail barricaded it. And to the extent that Conrail controls its own railroad tracks, it can do with it what it wants.
To the extent that it's not getting paid the $1,000 that is up, that Hillside was supposed to pay it in order to keep the crossing agreement in place.
Hillside had no reason to keep it in place. It had nothing to do with the north side anymore.
But it received payment from plaintiff, right? It received $2,500 from plaintiff and decided not to pay $1,000 of it
No, Your Honor.
After
That
16
$2,500,
years?
the $2,500 stopped being paid when Hillside stopped paying Conrail.
Any other questions?
Did you hear me? Oh.
Any other questions? No. Thank you very much, Counselor. Ms.
Thank you.
Welch, you have 1 minute.
60 seconds, Your Honor. And I only have a couple of points. One, it's misleading to go back to the 1994 agreement. As Justice Gonzalez pointed out, there was a 1997 amendment, and on page R54 of the record, that amendment specifically references the purpose of it, which is the sale of the property and to amend this agreement. So, but the point is that this was less than 30 days or about 30 days from the easement. They were contemporaneous. They certainly were contemporaneous under the law. The other point is my opponent said that they continued to pay for the license agreement because they were using the north side parking lot. There was never an agreement to that point, not in writing or not anything else. In fact, that's why my client brought a claim for trespass. And because they were trespassing. They were doing exactly what they couldn't do. They had no easement to park or pass through my client's property, and they were using the railroad tracks and just the parking lot of my client to pass through. There was never an agreement to that point. And my opponent mixes up the timeline here in terms of what happened first. What happened first is they stopped paying Conrail. Conrail complained about not getting paid. There was a fight about that. We tried to pay Conrail. My client tried to pay Conrail directly. Conrail wasn't having it. They wanted it from the counterparty. And finally, Conrail pulled the gates across the track, and then things really blew up. So that is our point here, Your Honor. I think the court has a sense that these contracts ought to be read together, or neither one makes any sense. The only sense of the license agreement is that it was for the benefit of the easement so that my clients could continue to get to Long Avenue and take the buses there. Pedestrians would come in through it. They could drive through it. And that's the only reason that they did this web of intertwined agreements back in late 96, early 97.
Thank you so much. Thank you very much. That concludes the oral arguments for today, March 18, 2021.
Thank you, Your Honors.